I'd like to call this meeting of the Peoria Planning and Zoning Commission to order. I want to welcome everybody attending tonight's meeting. We're glad to have you with us. We're going to begin with a roll call. Vice Chairman Jay Otluski.
Present.
Secretary Brian Patterson.
Present.
Commissioner Sean Hutchinson.
Present.
Commissioner Linda Grace.
Present.
Commissioner Clay Alsop.
Present.
Commissioner Joanna Condi. Absent. Alternate member Danette Dunn.
Present.
And I, Chairman Jeff Nelson, am present. I'm going to start by reading an opening statement that we begin all meetings with. This commission is comprised of Peoria citizens who have been appointed by the City Council to serve on the commission as a civic responsibility without compensation. Our duty is to study and review planning and zoning issues within the City of Peoria. The commission hears zoning cases, holds public hearings, or may conduct a study session on a topic. Decisions made by the commission are forwarded as written recommendations to the City Council, who take the final action. All hearings are conducted in accordance with rules for procedures and Robert's Rules of Order. Each case will be called in the order in which it appears on the agenda unless otherwise announced during the meeting. In the interest of maintaining a fair and efficient hearing, the commission adheres to the following steps. Chair will open the case. City staff will then provide a brief report and recommendation. The applicant is then invited to give a presentation. then any member of the public may provide testimony. Public testimony is limited to 3 minutes. When we call your name, please come up to the podium, provide your name and address. After all the testimony has been taken, we'll invite the applicant back to provide any rebuttal or final statements. The commission will then discuss the case and make its decision. Anyone wishing to speak must complete a speaker's request form and hand it to the commission assistant on my left. When providing testimony, we ask that you please be as brief as possible and avoid repeating statements already made by others. Any member of the public may appeal to the City Council the decision of the commission regarding a conditional use permit. The appeal must be submitted in writing to the Planning and Community Development Department within 15 calendar days of the date of the commission's decision. All commission recommendations on public hearing items, including general plan amendments, rezone, zoning code amendments, and special plans, move forward to a regular City Council meeting. The City Council will then act on the recommendation of the commission. The City Council may concur with the decision, modify it, overturn it, or remand it back to the commission for further consideration. We welcome citizens' comments, and as fellow citizens of Peoria, we thank you in advance for your participation. This will be the final call for any speaker request forms. If anyone wishes to speak, please fill out a speaker request form and provide it to Ms. Ernest at the end of the dais. Next item is our consent agenda. The consent agenda is for items that are routine in nature and consists of 3 items tonight. Item 1C, discussion and possible action to approve the minutes of the Planning and Zoning Commission meeting held on January 17th, 2019. Item 2C, is case CU 18-10, a request for a conditional use permit that would allow an expansion of vacuum stations for the Francis and Sons Car Wash located at 7934 West Thunderbird Road. And item 3C, case CU 18-08, a request for a conditional use permit that would allow a wellness clinic for cats and dogs. The proposed Cats and Dogs Wellness Clinic would occupy a vacant commercial building, formerly a Sonic restaurant, within the Ventana Lakes Village Commercial Center. The vacant building is located at 10246 West Beardsley Road. Do any commissioners have any questions or comments about the consent agenda before us tonight? Seeing none, may I have a motion?
Yeah, Mr. Chairman, I move to approve the consent agenda as presented.
Thank you. Commissioner Pedersen has made a motion.
I can second that.
And we have a second. All right, we have a motion and a second to approve tonight's consent agenda. Please vote. And it passes unanimously. Thank you, commissioners. We're now going to move on to our regular agenda. Under new business, we have one item before us tonight. Item 4R will be a study session to discuss a group home text amendment. This item will include a staff presentation and possible discussion regarding a city-initiated amendment to section 21-812, group homes of the zoning ordinance, as well as other applicable subsections referencing such facilities within the zoning ordinance. This item is for discussion only. No action will be taken at this time. With that, Mr. Gleason, will you be presenting tonight?
That's correct.
Very good. Please begin your presentation.
Thank you, Chairman, members of the Commission. My name is Cody Gleason, Senior Planner with the City of Peoria Planning Department. As referenced, what we'll be presenting to you tonight is essentially a framework and background for our group home regulations and really why we have them and what we're looking at amending as we move forward. There will be no action required on this item tonight. It is simply to provide you with some information and receive any feedback that you might have in that regard. So the term group home gets kind of thrown out in very general terms. Essentially what it is a facility that provides living quarters for individuals oftentimes with disabilities where they're receiving care and or supervision in order to accommodate their day-to-day activities. So if someone has a physical impairment where they need daily care and assistance in order to accommodate their needs, they would potentially live in a facility such as this with other individuals also receiving care from that home or care provider. There's a couple different subclasses or types of group homes. all of which would fall under the Department of Health. They have various bureaus depending on the type, but just to give you some general idea, oftentimes you'll see assisted living homes or homes for developmentally disabled. Also, one that's becoming more prominent is sober living homes. So those are all various types of group living facilities where people would reside there and receive care and or assistance with their activities. And we'll get a little bit more into what qualifies for those particular subclasses and that care in just a minute. So there's quite a broad array of federal, state regulations that address all the different types of group living facilities. But then beyond that, there's also agency regulations and policies that address, again, a myriad of subtypes. The biggest regulations that impact these types of facilities are the Fair Housing Act, the Rehabilitation Act, and the Americans with Disabilities Act. They all kind of touch on different parts, and as you can imagine with federal regulations, there tends to be overlap. So they address various aspects, so we want to make sure that when we're doing this code amendment, we're accommodating all of the requirements and we're not overstepping our bounds as prohibited by certain sections of those acts. As I referenced, the Department of Health Services is the state agency that essentially provides license to these types of facilities. It doesn't prohibit local jurisdictions from providing or adopting regulations, but there are certain regulations where we cannot implement regulations that would essentially prohibit them from certain areas. The idea is group living facilities would be in residential areas in order to ensure their integration into society rather than exclusion from certain areas. That's kind of the crux of especially the Fair Housing Act and the Americans with Disabilities Act. Well, we might have another slide. There we go. So as far as the federal regulations, as I said, really the purpose of them is to ensure that when regulations are implemented by, say, local jurisdictions, that those local jurisdictions are providing the opportunity for those facilities to integrate into society rather than exclude them. So what that means is we're trying to accommodate the intensity of the use without prohibiting them from operating similarly to a single-family home. Really, the intent is that they would be able to operate, they look, smell, and feel like any other single-family home. Oftentimes, the items that come up as contention with regard to the federal regulations are those preemptions that are trying to make provisions or allowances for those facilities. Some of the common violations that we see from local jurisdictions in researching court cases and Department of Justice actions against local jurisdictions, probably the most common one is separation regulations that aren't really tied to anything quantitative within the community. What that means is we have to ensure that we have a standard that's community specific. We can't simply pick an arbitrary number that may not specifically relate to our community. One of the local jurisdictions that had essentially run afoul of that and got in trouble for it was the city of Prescott. They went back and amended their code to where it would essentially address what the average block length was and allow for those types of facilities about every block. That way they can integrate again without being excluded. And I'll get a little bit more into in just a moment how we're anticipating addressing that and moving forward with our changes. As far as another common item that comes up is regulations that prohibit certain types of group living facilities to the detriment of one group versus another. So, for instance, the American with Disabilities Act identifies individuals who have a substance abuse addiction but are not actively using as having a disability. So those individuals fall under the protections of both the Fair Housing Act and the Americans with Disabilities Act. In that respect, we would need to ensure that any regulations we're implementing are treating sober living facilities similar to an assisted living facility. That way, we are providing essentially the same regulations for all types of facilities providing care to individuals with disabilities. Without addressing that, we are opening ourselves up for potential concerns down the road. So we want to make sure and establish standards that give us a measure to ensure the character of the area without detrimentally impacting a particular group. As I referenced, the intent of our regulations really is to comply with federal regulations, so modifying to ensure that we are in compliance with those federal regulations, state regulations, and the various department policies, while still ensuring the safety of the residents that reside within these homes. And I'll kind of address that in just a moment with respect to any particular safety measures for various types of homes. We're also looking to maintain the character of the area. So we don't want to have a facility that has, say, 6 employees that are parking all over the street and essentially causing a more intense impact than you would for a single family home with a bunch of teenagers that have a bunch of cars. So we're trying to draft regulations that, again, address the character and intensity rather than the group of persons living in the home. And ultimately providing a documentable process so that we can ensure that all the regulations have been met and they've proceeded forward to any state licensing body, namely the Department of Health Services with the state of Arizona. So what exactly are we looking at changing? There's a couple different items that we're looking to address with this. One being the definition of family. The reason that that's important is because each community has a definition of family. You would think that's kind of funny, you know, everyone, when you see a family, you know a family, but ultimately you have to provide accommodations for groups of persons that are unrelated. So if they're functioning similar to a family unit, you need to provide an accommodation for that. What we would be looking to modify here is modifying our definition of family to where essentially 5 or fewer unrelated persons living in a home operating as a family unit would not require any additional regulation. For homes with 6 to 10 persons living in the home, then at that point, even including the caregivers, they would be required to register as a group home and go through our process. The reason that we chose that cutoff and that number is we're trying to align the zoning ordinance similarly with the building regulations. So group facilities that have 6 or more persons, 6 to 10 really, they are required to obtain fire sprinklers for the occupancy of that building as a group home. So in aligning our definition, we're ensuring that certain safety measures are taken for the residents of those facilities, and oftentimes those residents, due to various disabilities, may have issues getting out in the case of an emergency. So we want to make sure that we're providing certain checks and balances that accommodate their needs and ensure their safety. Our separation distance requirement, I had referenced that a moment ago. What we have currently is 1,320 feet. What that means is any group home that comes in to register currently, they have to be at least a quarter-mile radius away from any other group home. That is a very common distance requirement, not only throughout the valley, but throughout the state. The reason that that's a problem is we have to identify community-specific regulations. So in order to do that, what we did is a rather extensive search with our GIS department in order to identify the average block length within the community. And what we came up with, we tried various iterations, south, central, north, north, south, east, west, just to see if there's any variation through various parts of the community. Ultimately, what we found is it's pretty standard as far as block length throughout the community. You're really looking at about 800 to 850 feet for your average block length throughout the city, any section if you average it out. So what we would be looking for with the draft regulations is modifying that distance requirement from a quarter mile down to 800 feet to ensure that we have qualitative community-specific standards that are not arbitrary and that ensure the allowance for the location of facilities within each part of the community. So by having that separation distance, it prevents them from conglomerating in one area and creating an institutionalized feel, and it still allows them within each portion of the community. The fourth item there really is a measure identified within the Fair Housing Act as far as what's necessary to ensure that we are reviewing them on a case-by-case basis. So the reasonable accommodation standard says that you have to make sure that should these facilities not be able to meet a certain requirement within your code, you're providing an opportunity to analyze that on a case-by-case basis and make a ruling as to whether or not an accommodation should be made and or can be made in order to facilitate the facility locating within the home. So an example of that would be, say, the distance requirement. If you have a location, I'm not sure if you are all familiar with the Skunk Creek area. If you have a home on one side of Skunk Creek that is a registered group home, and then that 800-foot separation distance would prohibit a home on the other side of Skunk Creek, that may be an opportunity to review it for a reasonable accommodation. The reason being is they are functionally different areas, and providing that accommodation for location across Skunk Creek would not create an institutionalized area or a clustering of facilities within a certain area. So it's meeting the intent and spirit of the separation distance without meeting the letter. And that's the type of accommodation that we would have to review on a case-by-case basis and make a determination on based on the requirements within the Fair Housing Act. So as I referenced, really what we're looking for tonight is just to provide you a starting point and a bit of background with regard to why we're doing what we're doing and ultimately what we would look for moving forward. Currently, we're here before you for a study session item to go over that. Moving forward, we would engage in a public participation process to see if there is any public input with regard to the proposed text amendment and the language itself. And then dependent on the outcome of that, possibly come back before you for another study session or simply come back before you for a recommendation that would move forward to City Council. We would look at a time frame, likely spring, just depending on how time frames line up to go to public hearing. But that is the extent of the presentation, but I'm happy to take any questions or comments that you might have.
Thank you for your report. We have some questions from commissioners. I'm going to start with Vice Chairman Atluski. You're first up. Go ahead, sir.
Thank you. The 800-foot radius, so is a quarter mile now, and we're dropping it to 800.
Chairman, Commissioner Atluski, that's correct. It would be reduced, in the draft language, it would be reduced from a quarter mile, 1,320 feet to 800 feet.
Okay, is that typical throughout the valley, or?
So, Chairman, Commissioner Atluski, that's kind of one of the things that we're trying to get away from is the typical standard because we have to make it community specific. The idea behind the federal regulations is that you're not selecting an arbitrary number, you're making something that's specific to your community and you're doing it with essentially quantitative standards behind it instead of, well, a quarter mile feels good, that's what everyone else is doing.
Okay, and I asked that because obviously in a neighborhood it could be, somewhere between 8 and 11 homes apart at 800 feet versus if it was a little larger, it would separate them maybe 12 to 15 homes apart, if that even became an issue. We don't, I don't know. Do we have an idea of how many there are already in Peoria?
Chairman, Commissioner Atluski, there's approximately 175 within the city currently. Okay. I would say is just to give you an idea of kind of subclass, I would say the vast majority, maybe 80%, 85%, are for senior care, and then the other remaining would fall into various different types.
Yeah, considering our size, that's not. I don't think the 800-foot will come into play very often. Then, the other question I have real quick is the reasonable accommodation. And I understand the reason for that, which makes perfect sense. But as we move forward and we see these come in, allowing variations, does that open us up at all to you allowed them to, but now you won't let me to, or?
Chairman,
obviously it does, but you've thought through this, I'm sure. So,
Chairman, Commissioner Atluski, it does in the respect that we have to evaluate each one, but ultimately, because we have to evaluate them on a case-by-case basis, it doesn't establish a practice for everyone that makes the same request each time. We would have to evaluate the merits of those individually.
Okay. All right. Thanks.
All right, Mr. Alsop.
Yeah, I'm interested in the text, and I'm assuming you guys just don't have the text yet. Is this the first step before you actually start drafting documents?
Chairman, Commissioner Alsop, we are working on draft language. Obviously, we would bring that before you before it went to council, but depending on the public feedback, we may bring it back before you in a study session. So we have a very rough draft right now that we're working on finalizing before we take any further steps.
So we're looking at getting the text, a couple months, I suppose.
Chairman, Commissioner Alsop, that's approximately yes.
Okay, thank you.
Commissioner Patterson, we have a question.
Yes. On the public participation, are there specific organizations you can reach out to make sure you get good feedback as opposed to just putting out an advertisement or some kind of a notice?
Chairman, Commissioner Patterson, there are various organizations that essentially advocate for various groups depending on what the subtype is. Those are certainly organizations that we can involve in the process and get their feedback with respect to the draft language.
Yeah, thank you.
Commissioner Grace, you had a question?
the source of the definition of a group home. Could you give that to me, and then maybe some background? It seemed very general and loose there, so I'm looking to where did that originate?
Sure. Chairman, Commissioner Grice, that's not really a definition. I just wanted to provide you essentially layman's terms as to what they typically are and feel like. As far as a definition, we do have one currently in our zoning ordinance, and we would be looking to make substantial modifications to that in our draft language. So we don't have one finalized yet, but we would look to modify that.
Do we have any other questions? I have a few. Thank you for the report. Very interesting. Look forward to hearing more. I'm not clear. Do we license these facilities right now in the city? Is there a licensing process through the city, or is it mostly through county or state? Or
Chairman Nelson, I guess it depends on terminology. So we don't issue a license to them. We register them with the city, and then they receive what's quote unquote referred to as a license from the Arizona Department of Health Services. Their subclass would determine which bureau they get it from, but ultimately the overarching agency would be the Department of Health that issues an actual license.
Gotcha. Okay. Thank you. I think it was a comment you brought up, just making sure that I would urge as well, let's include stakeholders in this conversation. They're the ones most impacted by it. I think that's important. Are we working with any outside consultants as well, or are we looking to the experiences of others, cities and towns, to see what works, what didn't work, and based on their experience crafting our text amendments?
Chairman Nelson, I've gone to quite a few inter-municipality meetings and essentially seminars about this. Prescott's kind of one of the forefront leaders as far as their regulations, particularly with respect to sober living homes, because they were essentially inundated by those types of facilities, mostly due to the weather.
Really?
Yeah, they are actually one of the top ones in the nation as far as sheer number of facilities.
Interesting.
So their city attorney has given quite a few speeches with regard to their practices. And I've also engaged other communities as to what they're evaluating. Like us, many of the other jurisdictions haven't made modifications in quite a long time to this set of regulations. And ultimately why we want to move it forward in an expedient manner is to ensure that we're complying with those federal regulations, because there are jurisdictions that have more or less been put on notice by either the Department of Justice or the Attorney General's office that their regulations are not in compliance with federal and or state regulations. So we want to ensure that we're not the laggard. We want to address them before it becomes an issue.
Makes sense. Has there been any outcry from the public on concerning these? You said that we had 175 of these. Has this been an issue in the city as far as neighborhoods complaining about a sober living house or a group home or something like that, or has it not really been an issue?
Chairman Nelson, we actually sat down with our co-compliance division because we wanted to find out, what are the issues that commonly occur with these, and is there something that we need to or can address to kind of stave off any further neighborhood concerns. In speaking with the code officers, they've had about 2 complaints, and those complaints are often with regard to either parking or weeds, which are the most predominant complaints that we get in the city.
Citywide.
Yeah.
And that's 2 in the span of 12 months, or is that?
2 that they can even recall.
Is that right?
Yeah.
Okay. So I think we can establish it's not been a big issue, not been a problem. Okay. All right. And the only other question I had was, it was on, actually I got 2, I'm sorry. The slide on conduct inspections, are we talking about fire department inspections there? Who's inspecting and what are we inspecting?
So, Chairman Nelson, just to kind of give you an overview of what the process looks like from an applicant perspective, when they come in to register a group home, they submit paperwork to us. We essentially put it on the map so that no other home is going to come in and prohibit them from that area due to the separation requirements. And then they call in for a building inspection. So the building inspector is looking for appropriate lighting, exiting, no bars on the windows so that there's safe egress in case of an emergency. But there's also a separate fire inspection. Those fire inspections are conducted annually. The building inspection is simply conducted when a change is made to the facility. So if there's a new owner that takes over to ensure everything's meeting requirements, they would have a building inspection. But again, every facility would have an annual fire inspection. And then ultimately, after they receive those approvals, they would come into planning, have us sign off to ensure that those approvals have been met, and they take that sign off to the Department of Health Services to show that they've met all local regulations and they can receive their license.
Oh, I got you. Okay. Circling back a little bit, we talked about the number of code compliance issues. I think you said 2. How about police calls? I would assume that's not an issue either, but have we consulted the police department, given them an opportunity to put in feedback as well?
So at the time that we had worked with code compliance, they were a part of the police department and engaged in any kind of nuisance information calls. So they had a record of that information that they would have provided us, but we can certainly follow up with the police department to ensure that there hasn't been any secondary calls that code compliance may not have been aware of.
I'm just thinking of potential sources of feedback that could help us craft a pretty solid text amendment in one shot. I know we always have to relook at things. Then, and lastly, and I apologize for all the questions here, it's an interesting topic. On the outreach piece of it, appreciate the fact we're going to include stakeholders. How are we going to reach out to the community? Are we going to advertise this? Are we going to be putting it on our Facebook page? I mean, talk about how we're going to be, getting this out to the community so anybody who has a vested interest in this topic can provide feedback.
Sure. Commissioner Nelson, that's one of the items that we're evaluating at this point. So we have the various advocate agencies that we can kind of search for and involve them. We would obviously post it on our website for any one that wants to review it. But we also have that list of operators, that 175 within the city that we could reach out to because with their application, they provide us obviously their contact information. So that's one method of really getting the folks that are involved on a day-to-day process eyes on the amendment. So we're evaluating everything right now and certainly trying to identify the areas that we can have the largest impact.
Great, thank you. That's all I had. Excuse me, Commissioner Dunn.
I had a question as far as oversight, because I know some of these homes, they come into a neighborhood and they'll rent houses, and corporate office might be in another state. And so how do you oversee that effectively? I know of an instance in Peoria, in fact, where they had a group home that was out without air conditioning in the summer. They couldn't get home the original owner. There's quite a few details in there that could be overlooked and not, hurt safety of the residents and also, of surrounding residential units.
Chairman, Commissioner Dunn, basically we would have to view it as any other single-family home. So any other rental home, we would not send out code compliance for an AC that's down. In situations like that, it would be a requirement to have it habitable according to the DHS regulations. So if we're made aware of something, we can certainly contact the Department of Health Services. They have an inspection or more or less a compliance arm that would go out and issue any violations or citations as it relates to their license for any measures that are not being met.
Could there be some type of licensing or oversight within the city as well? I mean, it doesn't have to only be air conditioning. That was just one example. There, I mean, there's quite a few examples.
Chairman, Commissioner Dunn, we could certainly have oversight with respect to our regulations, but items that we don't regulate as a municipality, particularly that we don't regulate on single-family homes, it may create an issue for us to try and regulate those on group living facilities. But that's certainly something that we can consult with our attorney's office as far as what measures we can take.
Thank you.
Okay, any other questions? All right, very good. Well, thank you, Mr. Gleason. Do you feel you have sufficient feedback from us and input from us to continue work?
I do. Thank you very much. It's always good to hear a different perspective, particularly from the folks that we're asking to review our regulations. So I greatly appreciate your input.
Appreciate the opportunity to review it. Thank you, everyone. A good discussion. All right, we're going to move on to our next item then, and that is call to the public. Are there any comments from the public on non-agenda items? All right. Seeing none, let's move on to our next agenda item, updates from staff. Does staff have anything to report tonight?
We do indeed, Mr. Chairman. Next meeting would be February 21st. We're back in council chambers. Then again, we are looking at having a March 7th meeting, same place, same time.
Good. All right, next is Planning and Zoning Commission updates and report of current events. Do any commissioners have any updates or current events to report? Quiet bunch here, huh? All right. Nothing? All right. All right, very good. Well, seeing no further business, I call this meeting adjourned.